Hi friends, today we are going to discuss about a very important topic. As everyone knows, December visa bulletin has been released by the Department of State. So we are going to discuss how the visa bulletin is look like, and the very important thing about the predictions, how the date will be moved in the further. That is a very important thing, right? Because the data filing we have, and we have final action date. So whether the final action date will reach the data filing or not, that is an important question. And I have few other questions to the attorney, like whether spillover has been completed from family base to the employment base, or still option is there, so the employment date can move further. So I have a lot of questions regarding the visa bulletin. Let's check with our attorney Henry. He is from the Manifest Law Firm, and you know very well Manifest Law Firm is giving free consultation for everyone. Just scan this QR code and use your free consultation. You can ask any question regarding your visa. Hi Henry, happy to meet you again, and thanks for the Manifest Law to arrange this meeting. Welcome Henry.
Hi, good to be back. Always good to see you.
Before going to the visa bulletin and just analyze the visa bulletin, I have a basic question. Most of the people ask this question, mainly from our viewers. They ask like whether if they are in EB2 or EB3, if they are trying to upgrade themselves to the EB1, what happened to their original petition on the EB2 and EB3? Will they stay as it is, or the original petition got removed and the EB1 petition alone it's available?
You don't lose an old case unless your employer already withdrew it, right? So if you have a EB2 or EB3 approval from your employer, let's say from 2017, and it's approved, then even if you file for EB1, both of those remain approved, and you can later use both of those, right? So for example, even if you get an EB1 approval, if your, let's say, EB2 becomes current, technically you could adjust status and take that job that the company filed EB2 for, right? So it still stays there. You don't lose it or give it up just by filing another case, or you're just basically using the priority date that's the oldest you have, but you still remain eligible under any of the categories where you have an approved petition.
Good to know, and yeah, you clearly explained it. The same thing goes for the downgrade, right? So many people downgrade always from EB2 to EB3 because EB3 dates are moving just ahead of EB2. So the same case, right?
Correct. So let's say, for example, you see there's movement in the visa bulletin, you downgrade trying to adjust, but then it retrogresses again and messes up the numbers. You didn't lose the EB2 just because you downgraded. If the numbers change the next month, you can again make the change. Annoying and messy, but it is possible to do. So you're not going to miss out on a case unless it gets revoked, right? So the only way you actually lose an approval is if you, let's say you leave the company and then the company files a withdrawal with USCIS saying we want to withdraw the I-140. But that rarely happens, especially if the case has already been approved long time ago, then they cannot even do it anymore. So if you have an old I-140 approval, odds are it's not going anywhere. You're safe.
Thanks, Henry. So, and I have one more basic question before moving to the visa bulletin. So we know that unused family-based green card will come every year to the employment-based green card. So we thought it already came from the family-based bucket to the employment-based bucket. Is there any possibility throughout the year again some can get it from the family-based green card?
The way it moves is anything that they didn't use in the last financial year or fiscal year goes to this new year's EB bucket, right? So from the family base to the employment. Now, I haven't seen the numbers yet. I don't know if they're even published.
No, they haven't published yet.
If they're not published yet, then it means that, you know, these might be coming in sometime during this fiscal year. So it's not just going to be counted in October, but it's going to be something that they're counting maybe next summer, you know, or next fall before end of the 2026 fiscal year. Because, you know, the government takes several months usually to even update us on the statistics, because right now we haven't even received the fourth quarter of 2025 approval rates and things like that. Yep. So once those come out, then we know actually how many family-based cases were approved in 2025 and how many numbers are left over. Then we're going to find out if any of that bucket goes into the EB. And then at some point during 2026, USCIS is going to have access to those numbers. So just because we haven't seen it yet doesn't mean that there's nothing coming. There could be some more coming, but we don't know yet how many.
Okay, so but there is a possibility, say example in summer they said these many X numbers unused family-based green card are available, so they will pass into the EB, the employment based, when they publish
correct.
it? Oh, okay.
Yeah.
That is good to know, because already the dates are going very good. So if they come something from the family-based green card, it will definitely push the EB line. Thank you. Let's go to the visa bulletin. So we have seen the October visa bulletin is always the jackpot visa bulletin, but last month visa bulletin, November visa bulletin, there is no changes on the dates. But now the December visa bulletin, it's coming very good.
Yeah, we're seeing some movement. Of course, people would like to see more movement, but any progress is good news to me, I think, especially with, for example, people from India are looking at EB1. We saw that moving forward by a month. So there is at least some progress, and that's a good thing.
Yeah, as you said, Henry, I have the exact number. So the EB1 is advanced, as you said, 28 days, and EB2 is 44 days, EB3 is 31 days, EB4 is 62 days, and EB5 unreserved is 150 days. So this is a good number I have seen, because I just compared this number to the last year. So I just taken the last year same November to December, how much movement they had. Just like only they moved EB2 and EB3, and it's only for 17 and 7 days. But this year the movement is very good. Why it is happening this year? From the beginning I am seeing, compared to the last year, the dates are moving very well. Is it because we got a good unused visa number from family-based green card?
It could be. They haven't released the family-based numbers yet, but behind in the government offices, when they are deciding how to publish the visa bulletin and what's moving there, they already have those numbers presumably, so that could be one of the explanations. Another one could just be that last year maybe they were a little bit slower in processing some of these cases, and now there's a little bit of a catch-up or making some progress on that.
I'm seeing the reason is EB1 is moving very, very slow. Why it is happening?
EB1 is moving slowly because there's a very large number of people who are applying for EB1 who have older EB2 or EB3 priority dates. From personal experience, I can tell you that we are filing a lot of EB1A cases, and I would say more than half, or maybe even more than 75% of people who we are filing them for have an old EB2 or EB3 priority date. So if you're looking at this as a lane of traffic or a line for the EB1 green card, then there's a line of people, and there is somebody who filing their case today with a new priority date, but then the person who is coming with a 2016 priority date is cutting into that line. So I think that the majority of people who are getting right now green cards and using up the visa bulletin numbers in EB1 are doing so with older priority dates, and that means keep cutting into the line like two lanes of traffic merging, and that's why the people who are actually in the EB1 queue from 2024, 2023 priority dates, they are just waiting there like, come on guys, why is my priority date not going? And it's because everybody else is cutting in line with their old PERM cases to get there faster.
Yeah, that's true, because if you are seeing the date, its final action date is 15 March 2022. So almost 3 years back. Oh my God, EB1 is 3 years back. That is really frustrating for the people who are applying. Now I got the reason. So so many people are moving here to there. So that's why we started the video, like what happened there, underlying petition on EB2 and EB3. So it will be stay as it is till it is approved to the EB1. Then it will remove from the line.
If somebody gets a green card in a different category, then their number will be removed from the line. So let's say if somebody's waiting in line for EB2, but then they get married to a U.S. citizen and get through a family-based, then once USCIS finally updates their system that, this person became a permanent resident, then they will remove that from the EB queue. That will impact how they move the visa bulletin. So that could also be one of the explanations actually for these changes in the visa bulletin, is that, for example, there are Indians in the United States whose kids are 21 and are sponsoring them, so they drop out of the EB queue because they get their green card through the family-based queue.
If some people are in EB2 or EB3 and they moved themselves to the EB1 and they started the I-485 on EB1, will that point the EB2 queue has been removed for them, or once they complete the interview and they got the green card, then the queue will be removed?
Only once they get an approval on the 485, because when you file the I-485, there is no guarantee yet that you will get an approval, even though it's very, very likely in most cases. But there's no guarantee. So USCIS is not going to start removing you from the wait lists or dismissing any priority dates. It's only once they've approved the 485 and then they know now this person is a permanent resident, then they can remove the priority dates from any remaining queues that where you are registered, whether you have one or two or even more I-140s from the past.
In the case, if the person is having EB2 and they are trying to upgrade to the EB1, and if their EB1 I-140 got denied by the USCIS, whether their original EB2 petition impact or it will be stay as it is?
No impact on that. The EB1 petition is completely independent. The only thing that the EB1 denial says is that in the USCIS officer's opinion, you don't yet meet the high standard of EB1, but it doesn't mean anything negative for the EB2 that's already been approved. Because the EB2 was approved, if it's a PERM, based on a company promising to give you a job in the future, and that doesn't go anywhere, right? So even if they say you don't qualify for EB1, that does not hurt your EB2 approval.
Other questions regarding, we are talking about the PERM. So one of our viewer asked this question. So their company is not started the EB2 or EB3, it seems, the PERM process, it seems, and he is having almost 1.5 years to complete the 6 years cap limit. So he is thinking about the EB2 national interest waiver, initiate the EB2 by himself. So my question is like whether the 1.5 is enough to get I-140 approved if he is eligible for EB2 NIW?
If you're using premium processing, then that gives you enough time to work on the case, gather documents, file it, and get a decision on it. With 1.5 years, that should be no problem. If you're filing in regular processing, I think you're going to run into potentially an issue because the average processing time of the I-140 is getting over 1.5 years, right? So that means that it might take longer. However, that might not be a bad thing because there's 2 ways for you to get an extension on the H-1B past the 6-year limit. The best one, of course, is if you have an approved I-140 because then you can get an H-1B extension for 3 years. But if you have an I-140 in the EB2 NIW category that has been pending for more than 1 year, even if there's no decision yet, it's still in process, then you qualify for a 1-year extension of your H-1B based on that pending I-140. So if you have 1.5 years to go for your H-1B, if you can file the I-140 in the next 6 months, then you will be eligible for another year of H-1B, even if the I-140 is still pending once you hit that 6-year point.
Wow, that's a great entry you said. Because a lot of people crossed 4.5 years and 5 years and they have only 1 year or 1.5 year. And they are thinking about if what happens if their employer is not initiate now. So they are thinking about the EB2 NIW process. Please, whoever is seeing, if you are in this situation like you are only 1 year or 1.5 year, just think about the EB2 national interest waiver, that you don't need any employer help. You can do it yourself and you can check with the Manifest law firm. They are giving the free consultation and you can check whether you are eligible for EB2 national interest waiver. So in that case, you can extend your stay after 6 years also. Yeah, that is a good thing, Henry. So I'm just taking the data filing date and take the current final action date and see remaining days they can move. EB1, they have to move 396 days from here to the next September, and EB2 is 200 days, EB3 is 327 days, EB4 is 167, and EB5 is 274 days. The numbers are huge. Do you think the USCIS aggressively move the dates going forward?
What I would predict is going to happen next is actually USCIS maybe next month or a month after that is going to say we will only accept adjustment of status or I-485s based on the final action dates. Because every month they decide if they will accept filings based on the dates of filing or the final action date. And right now, it's been, I think, 3 or 4 months in a row that it has been accepting cases on the date of filing. That means that a lot of people are able to get their cases going, but once there's a lot of cases pending, USCIS usually puts a stop on it and says, okay, no more. And how they do that, how they regulate how many cases they have pending is by switching between the final action dates and the dates of filing. For those interested, legally speaking, the final action date is the date that you have to have current in order to actually be able to get the green card. So the dates of filing, you might be able to start the adjustment of status, but USCIS cannot legally approve you for a green card unless your date is current on the final action date. So the difference between the final action date and the date of filing is just a buffer where USCIS is saying how many cases they want to receive. And of course, they recognize that it's going to take them some time to process an adjustment of status. So if they think maybe your final action date is going to be current in a year, then they will maybe already accept the adjustment of status application so they can do the background check and biometrics and give you an EID and all of these things to kind of get the process going, so that shortly after you reach the final action date, they can approve the case.
So they may reach the final action date to the date of filing towards the end of this fiscal year, or they may not, right? So it depends on the situation, how they are processing the cases.
Yes, I don't think the dates are ever going to be exactly the same. I think they're just going to kind of keep moving a little bit closer and further and closer and further. But I think there's always going to be at least 3 to 6 months, if not more, between those two dates.
Compared to the last year, compared to the last month, this visa bulletin is better, so it will give the big relief to the Indians, particularly because they had the most backlog on the employment based categories, and you have given the good knowledge about the EB2 national interest waiver. So whoever want to be processed faster and you don't want to depend on your employer, you can always check with Manifest Law Firm for the EB2 national interest waiver. Thanks, Henry. Thanks for your time.
Always a pleasure to be here, and again, happy to come back for any other discussions what your people want to know about.
Sure, Henry. Yeah, your knowledge is very helpful for our people, and we got a good feedback from our community. Thank you so much.
Okay, Nandri, thanks for inviting me.
Nandri.